Well, good morning, everyone. My name is Jeffrey Salant. I am the HOA Information Officer with the Colorado Division of Real Estate, which is a division of the Colorado Department of Regulatory Agencies, also known as DORA. Thank you for joining us this morning as we welcome Outreach and Education Coordinator Samuel Anderson with the Colorado Civil Rights Division to discuss fair housing laws and HOAs. There are 5 handouts attached to this webinar: a PDF copy of this presentation, a copy of the Colorado Common Interest Ownership Act, also known as CCIOA or Kiowa, a copy of the Colorado Nonprofit Act, a handout on reasonable modifications under the Fair Housing Act, and a handout on assessing a person's request to have an animal as a reasonable accommodation under the Fair Housing Act. You may download them by clicking on the blue links located under the Handouts tab on the GoToWebinar control panel. This webinar will be recorded and uploaded to the division's YouTube channel. Once it's available, you may access it via the link to the division's YouTube channel on the PDF handout of this presentation in the second to last slide. Please note that the information provided during this presentation is for educational purposes only, and it is not meant to provide or to be construed as legal advice. Any legal questions should be directed to your attorney. And now please join me in welcoming Sam Anderson from the Civil Rights Division here in Colorado. Sam, may I hand off control to you at this time?
Yes, Jeff, please do. Thank you.
All righty.
Well, good morning, everyone. I'm just going to give a moment. Hopefully, my presentation should be displaying on your screen now. And as Jeff mentioned, thank you for that introduction again. I'm here to talk to you this morning about Colorado's fair housing laws. And of course, we're going to be focusing on how those fair housing laws might affect or impact HOAs, homeowner associations. Jeff already introduced me, but again, my name is Sam Anderson, the Outreach and Education Coordinator for the Colorado Civil Rights Division. There's a picture there of me to put a face to the name, and my direct contact information is also on your screen. As Jeff mentioned, you do have a copy of this presentation if you want to refer to that later. Feel free to reach out with questions you may have about the Colorado Civil Rights Division or the Colorado Anti-Discrimination Act, also known as CODA, that we'll of course be discussing today. Keep in mind, CCRD is not just focused on fair housing. We also enforce Colorado's employment anti-discrimination laws and anti-discrimination laws in places of public accommodation. Again, Jeff had given a quick disclaimer just to really drive that point home. I'm going to reiterate that this morning's presentation is not intended to be used as legal advice, and it's not a legal directive. You can reach out, again, you can reach out with questions after the presentation. I will do my best to answer those where I'm able, but as Jeff mentioned, if you're seeking legal advice, then you need to consult with an attorney, because unfortunately, we're just not able to do that for you, but we're happy to provide you information about the law and the agencies that enforce it. And now, as Jeff mentioned, both of our divisions, Jeff being with the Division of Real Estate, myself being with the Colorado Civil Rights Division, we are divisions of DORA, the Department of Regulatory Agencies. So DORA is an umbrella department of the state of Colorado with 10, depending on if you want to call one of them a division or not, 10 divisions that exist under that umbrella of DORA. So just for your information, other divisions are things like Division of Banking, Division of Financial Services. Biggest one would be Division of Professions and Occupations. That's the division of DORA that licenses and regulates various licensed professionals. So anything from a massage therapist to a dentist to a plumber licensed through DPO. So keep in mind, DORA is an umbrella state department with individual divisions underneath it. Like this morning, Division of Real Estate, Jeff and myself were collaborating because sometimes there's interplay between divisions, but indeed, keep in mind the divisions are separate entities with separate roles separate statutes and rules and regulations to enforce. Now, what the Colorado Civil Rights Division is tasked with is enforcement of the Colorado Anti-Discrimination Act, or CADA, C-A-D-A. So CADA is the set of laws in Colorado that prohibit discrimination, broadly speaking. And CADA applies to 3 areas: employment, housing, and places of public accommodation. Obviously relevant today is CADA's application to housing. And we're going to see how CADA's prohibition on housing discrimination applies to HOAs. It applies to both the members, the homeowners of HOAs, and also the HOA board, HOA property management companies. We're going to see that the housing section of CADA is very broadly applied. It applies in more instances than not, certainly not just in rental or landlord-tenant situations, as we'll see. I'm going to briefly just talk about some procedural things, explain a little bit more about what the division does and how CADA is applied before delving more specifically into housing. And I do that because I think it's helpful just to understand, practically speaking, somebody believes that they've been discriminated against, what happens next? How does CCRD deal with that allegation of discrimination? And I'll get to that in a moment, but let me just clarify a few other things that CADA does. CADA, again, the Cardinal Anti-Discrimination Act. So it prohibits discrimination, we know that. It's also, CADA is also what creates the Civil Rights Division. Again, that's the state office that I work for, but also the Civil Rights Commission. I'll be introducing the commission and what they do here in just a moment. But importantly, both the division and commission are statutory agencies, meaning that we only exist through the permission of the legislature. Every 9 years, we go under what's called the sunset review. The legislature then decides, the General Assembly decides, are they going to reauthorize our office to exist? We last did that a couple years ago, and so we're good to go until 2027. CADA also defines certain terms. So for instance, shortly, we're going to be looking at the definition of housing, and we'll see how that definition is applied and how that definition includes basically any housing situation in Colorado. Again, not just renters and landlords and not just realtors, but also HOAs, HOA members, property management companies. CADA also very specifically sets out the division's power, process, and procedure, so how we investigate a complaint of discrimination, the complaints that we can accept, etc. And finally, CADA enumerates protected classes. Protected classes are the characteristics or bases which a person cannot be subjected to discrimination because of. And we'll focus today, or I'll try and focus today, on some of those areas, the protected classes, where we see cases that involve HOAs. Now, certainly any protected class, discrimination with an HOA could be based on any protected class potentially, but what I'm saying is that I'll try and focus on the areas where complaints are likely or most statistically common to occur. So again, Civil Rights Division, that's who I work for, one division of DORA, and CCRD's tasked with enforcing CADA. We enforce CADA primarily through the investigation of complaints of discrimination. We also offer what's called alternative dispute resolution, ADR. That's just another term to use really for mediation. So when complaints are filed with our office, we do offer mediation services if the parties are amenable to trying to settle the case before an investigation and opinion. CCRD also engages in community outreach and education, just like this webinar this morning. As mentioned, CADA very specifically dictates a lot of how cases are processed and the procedure through which they go through the division and commission. Our current staff number is 31. We have a couple open positions to be fully staffed, but we have just the one office for the entire state of Colorado. And importantly to stress, CCRD's we may only have the one office in Denver. Our jurisdiction is the 4 corners of the state. So anyone within the state of Colorado alleging housing discrimination would be able to file a complaint of discrimination with our office. Now, I referenced just in passing the Colorado Civil Rights Commission, which is importantly a separate entity from the division. So the division, the part of DORA that I work for, we are state employees. We are neutral. We are a neutral agency tasked with investigation of these complaints, engaging in mediation, and also outreach and education. The commission is inherently different. The commission is not comprised of state employees, but instead, when it's fully impaneled, right now we do have a vacancy. So there's only 6 members of the commission, but when it's fully impaneled, there's 7 members. By statute, that membership is bipartisan and includes representatives of both business and employee organizations. Relevant to what the division does, the commission hears appeals of dismissals, and the commission also has the authority to pursue cases where we find discrimination and the parties aren't able to settle. The commission has the authority to pursue those cases further through their own litigation. In other words, when the division investigates a case, finds discrimination has occurred, and the parties are not able to settle, the commission is going to pursue that case further through their own litigation. In other words, the commission is going to step in. They're going to become a named party, and they're going to sue the entity that has been found to have discriminated by CCRD's investigation. So kind of what I just talked about is shown on a very simplified diagram on, well, might disagree if it's very simple, but a simplified diagram of the division's complaint process. Key steps are intake, investigation, and determination. Division receives complaints of discrimination at intake. We investigate those, and then we issue a determination of whether or not that complaint and the complainant who's alleging discrimination has demonstrated that there's been a violation of the Colorado Anti-Discrimination Act. As mentioned, after a complaint is filed, we do offer mediation services. If parties are able to successfully mediate, when it comes to a housing complaint, they enter into what's called a no-fault settlement agreement. That would be the end of the case. The parties would go on their way. If not, case is investigated, and again, the division is going to issue a determination. Termination can be one of no probable cause. In other words, the person who alleges they were discriminated against has not demonstrated there's a violation of CADA. That's the no probable cause is essentially a dismissal, but that dismissal can be appealed to the Civil Rights Commission, who then can reverse that determination, uphold it, send the case down for additional investigation. On the other hand, if the division does find sufficient evidence to conclude that CADA has been violated, that's what's called a probable cause filing. And in that instance, the parties, so the complainant, the person who's alleging that they were discriminated against, and whatever respondents that may exist. So in an HOA situation, the complainant might be an individual homeowner who, let's just say, sought a reasonable accommodation. Let's say that they lived in an HOA that had rules that said no, absolutely no dogs over 50 pounds, but this person sought as a reasonable accommodation to be allowed to have their 60-pound German Shepherd as their assistance animal, and that was denied. That complainant would then be alleging that they were denied a reasonable accommodation by the HOA. So the complainant would be the individual homeowner, but the respondents could be a number of, it could be the HOA board itself, presuming that it was the board that denied the reasonable accommodation request. It could be the HOA property management company that processed that, and it could even be individually named board members and potentially other. In housing cases, there can be multiple respondents because multiple entities might be involved in the alleged violation of CADA. When it comes to liability, that's who is more at fault. That's something to be determined later on. The division's role is to determine if there's been a violation of CADA. So that was just a quick overview of how CCRD works, how our office operates, how a case goes through our office. Let's talk about the law in specifically, let's talk about the law now. Of course, CCRD is enforcing state law, and I've only introduced and talked about the Colorado Anti-Discrimination Act. And that's really what our focus is today. But it's important to keep in mind that federal law addresses a lot of these same things. And a lot of times, a housing provider, and when I say housing provider, your thoughts might go to, well, he's talking about a landlord or an owner of an apartment building. No, it's not that limited. Housing provider is meant to be a very broad term to include anyone that's basically engaged in any housing related transaction. So a realtor would fall under that housing provider title. An HOA, property management company, all fall under that title of housing provider. Even an architect or a developer could fall under that definition of housing provider. That's just meant to be an umbrella term for simplicity's sake. At any rate, housing providers are not just subject to these state laws, but also to federal laws that are going to be in play too. That means that an entity could potentially be violating state fair housing law as well as federal fair housing law. So when it comes to federal fair housing law, that's primarily enforced by U.S. Department of Housing and Urban Development, simply referred to as HUD oftentimes, specifically their Fair Housing and Equal Opportunity Office. HUD is huge. For those, I'm sure most people know that, but HUD is huge. FHEO is just one section of HUD. It's completely separate than the parts of HUD that, for instance, administer Section 8 vouchers or deal with homeless shelters. HUD, again, enforces the federal fair housing laws. Federal fair housing laws, by and large, are encompassed under Title 8 of the Civil Rights Act of 1968. Sometimes it's referred to simply as Title 8 or FHA, the Fair Housing Act. Other laws that deal with discrimination in housing besides Title 8 are Section 504 of the Rehabilitation Act and Titles 2 and 3 of the American with Disabilities Act. So Title 8 deals with discrimination based on race, color, national origin, religion, and sex. Section 504 in the American with Disabilities Act relate to disability-based discrimination. And there are various other federal laws that might be implicated. Now, why do I bring up these federal laws? As mentioned, these federal laws can apply at the same time as state fair housing laws, but it's also important to understand that HUD and the CCRD work together in the enforcement of fair housing laws. Specifically, CCRD has been designated as what's referred to as a FAP, or a Fair Housing Assistance Program, FAP. FAPs are local or state agencies that are enforcing fair housing law, and HUD has reviewed those fair housing laws and said, do these state or local fair housing laws meet our minimum? Are they at least as good, so to speak, as federal fair housing laws? Do they provide at least the same protections? If that's the case, if this local or state fair housing laws provide at least the same exceptions as federal law, they're deemed substantially equivalent, which allows what's called this work share agreement. So because of this work share agreement, it means that if a person files a complaint, a fair housing complaint with the CCRD, and the housing at issue would also fall under federal jurisdiction, that case would be dual filed. So it would be given a CCRD case number and a HUD case number, but there'd only be one investigation. Now that's important usually only if a case goes to litigation later on. The important thing to keep in mind though is that a case could be filed, or an investigation could occur with one agency, but the person could be preserving both their rights to pursue litigation under federal law and federal district court and under state law and state district court. And there's various reasons that an individual litigant would pursue a case in federal or state court, not that we're going to get into today. Now, federal fair housing law is indeed substantially equivalent. The state of Colorado's fair housing laws, which, as an aside, Colorado actually has had fair housing laws on the books longer. It was the first state in the nation to put fair housing laws, statewide fair housing laws on the books. That was in 1959 when fair housing laws were passed statewide in Colorado. And those fair housing laws predated the Federal Fair Housing Act by 9 years. So you could say that it's really the federal laws that are substantially equivalent to state laws. But at any rate, Colorado has now today provides even broader protections than federal fair housing laws. Specifically, the Colorado Anti-Discrimination Act, or as one specific example, Colorado fair housing law protects from discrimination based on sexual orientation and gender identity, as well as marital status. Sexual orientation and gender identity are not explicitly listed as protected classes under Title VIII. However, courts have, in a recent US Supreme Court decision related to an employment case, it's likely that it's safe to conclude that sexual orientation and gender identity are also protected under federal law. Regardless, at the end of the day, still protected under state law, as is marital status. And I'll talk a little bit more about sexual orientation and gender identity and marital status protection shortly. But that's enough about federal law. Again, the important thing to know is that federal law provides a lot of the same protections. CCRD has this work share agreement with HUD to dual file cases, and that Colorado law is actually broader in its application to housing. So Colorado fair housing law applies in more instances than federal fair housing law, and it also provides greater protection as far as protected classes. And I'll get to the specifics on that shortly. But let's look at Colorado law to better understand where it applies. Two key definitions: aggrieved person and housing. Aggrieved person, that is really the only time we use that phrase is actually in the statute, because really that's the complainant, that's the charging party. That is the individual who believes that they've been subjected to discrimination and they're filing a complaint with our office. And you can see that definition is very broad. Any person who claims to have been injured by a discriminatory housing practice, and it even goes on to include individuals who believe that they will be injured by a discriminatory fair housing practice. So it's even a speculative harm that a person might be alleging. Now, switching over to the definition of housing, you'll also see that that's very broadly defined. Any building, structure, vacant land, or part thereof offered for sale, lease, rent, or transfer of ownership. So you can see housing, again, very broadly defined. What isn't included in housing starts right there after that semicolon. And it's, as we're going to see, it's a very narrow exemption. And I'll get to that shortly. But let me stress the point of the coverage of CADA extending to HOAs and board members. So the housing section of CADA provides that no person shall engage in these discriminatory housing practice. So person, you'll see the definition that appears in CADA here, and person means one or more individuals. It includes limited liability companies, partnerships, and underlined in bold there, associations. So HOAs are considered persons that can violate or engage in unfair discriminatory housing practices pursuant to these statutory definitions. Now, going back and considering that definition of housing and what is not included in housing, or in other words, what is not subject to the Cardinal Anti-Discrimination Act. And this is what appears after that semicolon of what is housing, which remember is any building, structure, vacant land, or part thereof offered for sale, lease, or transfer of ownership. So what is not housing? Rooms or units offered for rent or lease in a dwelling intended to be occupied by no more than 4 families independently, and one is maintained and occupied in part by the owner and lessee of said dwelling. So this is sometimes called the Mrs. Murphy Exemption. Really, the simple way to look at it, the Mrs. Murphy Exemption is, to give it a general definition and application, it's kind of like a roommate exemption. If Mrs. Murphy wants to rent out the rooms in her home to other individuals, as long as she's not renting out more than 3 rooms, the 4th being her own, she can, quote unquote, discriminate. She can, she's not required to make reasonable accommodations. She can say that she's only going to rent those rooms to other women who attend the same church as her, and she's not going to be violating CADA. That's the only exception. So an HOA can't write out its coverage of CADA, like in its covenants or something like that, or its articles of incorporation. You cannot contractually exclude yourself from CADA. You cannot exempt yourself from CADA through some fancy legalese. If it doesn't fall under this Mrs. Murphy exemption, it is a situation where CADA applies and where discriminatory housing practices are prohibited. Now there's some other narrow exemptions. So that's the broad exemption. There are some other narrow exemptions that might come into play. Probably none of them that are applicable to any HOA discrimination situation that we'll be discussing today. But another narrow exemption relates to the sale of a single family home. You can see the statutory language for the exemption is on your screen. It's very long. I'm not going to go through it. Basically though, the exemption is so narrow, it only applies to the sale of a single family home, and it only applies to discrimination based on familial status. The takeaway here is that you can generally rely on Colorado's fair housing laws to apply to any housing in question unless it falls under that Mrs. Murphy exemption. In other words, all HOAs in the state are going to be subject to Colorado's fair housing laws and also to federal fair housing laws. Federal fair housing laws are also broadly applied. If there's a question of like a landlord, for instance, being covered, federal law considers the number of properties that are covered. It has to be more than 3, excluding the individual owner's primary residence, or really more than 4. But again, I don't see any situation where federal fair housing law wouldn't also apply to homeowners associations in Colorado. So I've said a few times, and we all know that discrimination is prohibited by state and federal law, but what does that look like? Well, discrimination, generally speaking, can take 2 forms. Discrimination can be disparate treatment. That's the more common complaint of discrimination. Certainly the most common type of discrimination complaint the division sees. So that's just an allegation that a person is being treated differently, negatively, because of or based on their protected class. So this complainant is alleging that because of their race, because of their religion, because of their disability, they're being subjected to unfair housing practices. Pretty straightforward and easy to understand. Disparate impact is a bit more nuanced. That's where you have a rule or a policy or procedure that's being enforced by the housing provider. And on its face, it applies to everyone. But the impact, the actual impact of applying that rule disproportionately affects a certain group. An example of that is I'm going to be showing here shortly. It comes to rules related to pool usage. So I'm going to give you some examples, illustrative examples of that. So we know disparate treatment and rules that have a disparate impact are discriminatory. But let's look at a couple at the specific ways that CADA contemplates that these housing practices might be discriminatory, or what specific actions might constitute unfair, discriminatory housing practices. Some of them might not be something that HOA would be involved in. So for instance, a refusal to rent or sell. Unless somehow, unless the HOA tries to intervene in the sale of one of the homes that is subject to the HOA. Applying unequal terms and conditions of sale and rental. Now, unequal terms and conditions could also extend to unequal terms and conditions of members of the HOA. So for instance, unequal terms and conditions when it relates to the use of the common elements in the HOA. I'm going to get to that shortly. The most common fair housing complaint, including the most common fair housing complaint that we see anecdotally filed against HOAs, is an allegation that the HOA or its board members or property management company refused to allow a reasonable accommodation and or modification that was necessary to accommodate that person's disability. And again, I'm going to focus on that more a little bit later as we wind up. Something to think about, an example of that would be assistance animals or emotional support animals. I kind of alluded to that fact, the idea of an HOA not providing a reasonable accommodation in the form of allowing an individual with a 60-pound dog to have their emotional support animal because the HOA has a strict 50-pound limit on animals. Others, redlining, steering, probably not likely to come up in an HOA. Important to keep in mind is harassment is an unfair housing practice, and it's going to be a violation of COTA if that harassment is based on a person's protected class. And I'm going to talk about shortly considerations. What if it's two different individual homeowners and one of the individual homeowners is harassing the other one based on protected class? Question, it becomes, what, if anything, is the HOA expected to do in light of that? Advertising with discriminatory preference or limitation is a violation, misrepresentation of availability, and retaliation. Retaliation, I'm going to expand on this slide, skipping over steering and focusing on retaliation. So when a person engages in a protected activity, they cannot be retaliated against for doing so. For our purposes, a protected activity is making an allegation of discrimination. So maybe a homeowner goes to the HOA board meeting or attends it virtually in light of COVID and makes an allegation. They say that I believe that the HOA, that the board is discriminating against members who, based on their race for these reasons. That person has just engaged in a protected activity and cannot be retaliated against for engaging in that protected activity. It's also true if that person makes an allegation of discrimination, not just to the board directly, but also if they make an allegation of discrimination by filing a complaint with CCRD or with HUD. Those are protected activities. The person cannot be retaliated against for doing so. So let's again use that, keeping with that example. Let's say that a homeowner attends, virtually attends an HOA board meeting, and they say that they believe some decision or some policy that the HOA board recently implemented is discriminatory. And they state their reasons for believing that and why they believe it's discriminatory. And then a week later, that person who made that complaint is suddenly getting notices of fines for covenant violations. And maybe indeed those are covenant violations, but prior to that person making that complaint, there was no enforcement of that specific issue. Let's say it's something like you need to bring, after trash pickup, you need to bring your bin out of your, you need to make sure your bin is out of your driveway and put away within the same day, within 24 hours of trash pickup. And maybe it's a rule on the books, but generally it just hasn't been enforced for years against anyone. But then this individual makes this complaint of discrimination during the board meeting, and suddenly he's getting notices that he's going to be fined for leaving out his bin. Well, that could definitely be a issue of retaliation because it wasn't an issue and it wasn't enforced until after the complaint. Now contrast that with if this rule was consistently being enforced and this individual made the complaint and then got a notice of this, he might claim retaliation, but then the HOA would be able to say, no, we consistently enforce this rule. Yes, we'll concede that he made this allegation of discrimination, but we were enforcing this rule before he did so, and we will continue to do so after. So it's important for both potential parties to understand that a person who's engaged in protected activity is protected from retaliation. So a person cannot be retaliated against for engaging in that activity, but also a person who's claiming retaliation must show that whatever the alleged retaliatory act was because of their protected engagement in a protected activity and not for some other legitimate non-discriminatory reason. Let's consider some some illustrative examples now of prohibited housing practices that might arise in an HOA setting. If you remember, one specific prohibited housing practice is the application of unequal terms and conditions. Let's consider the application unequal terms and conditions as they relate to pool rules. Pool rules are of course fine but those pool rules cannot target a specific group or otherwise discriminate based on protected class. Now, some for instance, would be everyone would know and clearly understand why they're discriminatory. So for instance, if there was a pool rule that said on the weekends, only white homeowners can use the pool, that's clearly, undeniably on its face, discrimination based on protected class. However, I'm again just using it to illustrate the point. It's discriminating based on protected class. But what if you have, but that's one that's not facially neutral. On its face, it says it draws a distinction based on race. But what about a rule that doesn't draw a distinction like that? That on its face, it appears to apply to everyone. So for instance, no pool usage by anyone after 10 p.m. That's a rule that's facially neutral. It applies to everyone. And because there's no other caveat to that, I would argue that would not be discriminatory. It's not disproportionately affecting any group. But consider a rule that arguably applies to everyone, but necessarily impacts a different group. So consider a rule that says no one under 18 without a parent or legal guardian. Well, maybe at first you say, well, that's pretty reasonable. Well, that disproportionately impacts families based on familial status. And while it's fine to say that to have rules that are going to ensure compelling business necessity, i.e. ensure safety in the pool, you need to have rules that do that in the least restrictive means. And saying no one under 18 without a parent or legal guardian, well, what about somebody who's 19 but who can't swim? Well, they're not subject to that rule. And if that person is there, if that 19-year-old goes and tries to swim and drowns, well, they were following the rules. So really, you're not meeting your compelling business necessity. So by having rules that are based on age instead of ability is a potential way to get yourself in trouble with unequal terms and conditions when it relates to pool rules. Now remember, whatever the allegation, whenever a person is complaining of discrimination, be it unequal terms and conditions or harassment, the person claiming discrimination needs to be able to tie it back to a protected class. And if you recall, I said at the beginning, CADA specifically enumerates protected classes. If it's not a protected class, it's not going to be the basis for a complaint. So on your screen, you'll see all the protected classes that are protected when it comes to housing. They're a little bit different than employment. So for instance, in employment, you have age. You don't have age here. But when it comes to housing, these are your protected classes. I mentioned earlier the most common complaint is an allegation that a HOA refused to allow a reasonable accommodation, usually in the form of an assistance animal. Necessarily, the protected class that relates to that is disability. So reasonable accommodations and assistance animals necessarily relates to disability. Disability, I'll elaborate on shortly, but includes both mental and physical disability. Others, pretty straightforward. Race, color, national origin, the country in which a person was born, ancestry could be the same as national origin, could be different. Religion is a protected class, as is creed. Religion, a sincerely held religious belief. Creed, more broadly or general, a guiding principle or philosophy to which a person adheres. Sex, male or female. Marital status. Marital status is one that is not a protected class on the federal level, but is a protected class on the state level. So that's marital status being single, divorced, married, of course. All bases, a person cannot be subjected to discrimination because of that. Likely you'd see that maybe in a rental situation or something, but what if HOA says that, for instance, the community room is reserved for married couples to have date nights on Thursday night? Well, there's a few problems with that. Marital status, though, is clearly one, clearly a protected class that is being singled out. Familial status, I talked about that before with the pool rules, and I'm going to elaborate on that. Retaliation I've already addressed. And again, sexual orientation, which per the definitions in CADA includes transgender status, which is more appropriately phrased as gender identity, are protected classes. So a person cannot be discriminated against based on their sexual orientation. Simply put, that's being gay, straight, or bi, or their gender identity. In other words, being a transgender individual. Now, effective January 1st of next year, source of income is also a protected class. That relates more to rental things. I'm not going to get into that now, but sometimes HOA, members of HOAs rent out their properties. Sometimes HOAs have rules that relate to rental. So consider how your existing rules that apply to the rental of HOA member properties that are rented out might be impacted by that source of income. Familial status. So I've mentioned that as an example when it comes to pool rules. Familial status, you have the statutory definition on your screen. It's rather long. Really what you need to know is familial status includes any household where a member is under the age of 18, and it also includes pregnant women. There doesn't need to be a biological relationship. There doesn't need to be a court order of guardianship or anything like that. Any household where one member is under the age of 18, and again includes pregnant women. Now I use the pool rule as an example of unequal term and condition based on familial status. What about even just a broader rule? Well, here's a case that resulted in litigation. I'm not going to give the details, but this was a real association rule. All children must be supervised by an adult at all times while playing outside. Basically, the rule said kids can't be out in the common areas of the community. As was alleged in the complaint, and ultimately the complainant prevailed, this requirement of constant parental supervision of all minors, even teenagers, is oppressive, unnecessary, and unfairly burdensome on families with children. And I'll tell you, the settlement of this case required the association to expend $10,000 to build a playground for children to use. Harassment. So harassment is something that some HOAs might not be aware of, that they could be held liable even if they are not the board members themselves, or the property management company itself is not the source of the alleged harassment. So what if there's a dispute between two neighbors, two homeowners, and that dispute or conflict is because of a protected class? Let's say one neighbor is hurling racial slurs and epithets at their other neighbor. The question becomes, what, if anything, can the HOA do to intervene in that situation? Now, there's no expectation that HOAs intervene in all neighbor conflicts, but if the HOA is aware of a neighbor conflict where there is discriminatory harassment based on protected class, the question then becomes, is the HOA aware of it? Did they have reason to believe? And what, if any, tools did that HOA have at its disposal to address it? Maybe there's governing documents that talk about quiet enjoyment and there's an anti-harassment clause. Maybe there's an HOA web platform and one of the individuals is putting harassing statements on that platform. The harassing neighbor maybe needs to be shut down. Their access to that communication tool needs to be shut down. Again, HOAs are not expected to intervene in every conflict and cannot ultimately control third parties. The question becomes, if an HOA is aware of this hostile environment, what are they doing, if anything? And usually there's something. Even if the HOA can't eliminate it, there can be at least be attempts. Maybe even if it's just sending a letter to the accused harasser, reminding them of any relevant clauses in governing documents. Something that is a hot topic lately, politics, yard signs, and free speech. Now, importantly, political affiliation or association is not a protected class. Remember, it has to be enumerated protected class to be the basis of a complaint of discrimination. It's very reasonable to say, well, hey, what about creed? You said creed is a guiding philosophy or principle which somebody adheres to. Certainly that's political affiliation. Sorry, creed is explicitly excluded. I'm sorry, political affiliation is explicitly excluded from the definition of creed in the Colorado Civil Rights Commission rules. So creed does not include political affiliation or association. So really, you know, if there's an allegation of discrimination because of politics, then it's not really something that the CCRD can address because it's not a protected class. Now, keep in mind that there's other laws, and specifically per the CCIOA, HOAs can regulate time frame and display of political signs. There's all sorts of things around that. Ultimately, though, this comes down to free speech and free association, which are constitutionally protected rights. These are every citizen's rights that they have. CCRD does not enforce constitutional protections. CCRD enforces the Cardinal Anti-Discrimination Act. Constitution is your shield against the government. It's your right, but you don't. The CCRD does not enforce First Amendment complaints. Now that relates to politics and yard signs. Well, lately there have been a lot of other displays that maybe don't necessarily implicate a specific election or ballot measure. So you have to consider, what if your HOA is allowing a homeowner to display a thin blue line flag, but isn't allowing a pride flag? That would likely be discriminatory. Those two things, while thin blue line could be a creed claim, and a pride flag could be a sexual orientation and or creed. So if you're going to pick and choose, HOA should not pick and choose. If they're going to allow the display of something like a thin blue line flag, they better be prepared to allow a pride flag to show. Otherwise, it's picking and choosing, and that's where things can really come into a potential discrimination complaint. Religious accommodations. These are some things. These are sometimes some easily forgotten by HOAs and housing providers, because usually you don't see religious accommodations in housing. Usually, if anywhere, you see them in employment, but there's still a requirement to make an accommodation. But usually, again, you just don't see accommodations in housing related to religion. Another way, instead of thinking about accommodation, think about unequal treatment based on religion. So reasonable accommodation, just like with disability, is an exception to a rule or policy, something like that. I talked about assistance animals. So it might be, you might have a rule that allows the display of Christmas decorations, but not the display of Hanukkah decorations. Well, that's unequal treatment or unequal terms and conditions based on religion. You're allowing Christians to decorate, but not Jewish peoples. A real life example of this was a condo association that had hallway rules. So it's a condo, internal hallways, and it didn't allow anything basically outside the door. Well, a member, a homeowner, a condo owner in that condo association sought to be allowed to display their mezuzah, which is a scroll of parchment with a passage from the Torah that is, it's just a small little rectangular box that some Jewish people will hang outside their door. They said, allow me an exception to this rule that doesn't allow this display because this is my sincerely held religious belief. Allowing a person to display a mezuzah in the hallway is not going to result in an undue burden, which would be the only reason such a request would be denied. So disability, that is the most common basis for complaint. Disability is the only place where reasonable accommodations come into play, and disability is where assistance animals, emotional support animals, service animals come into play. A person cannot be discriminated against because of disability. If a person has a physical or mental impairment that substantially limits a major life activity, they are disabled and may be entitled to a reasonable accommodation if that reasonable accommodation is necessary to allow them the full and equal enjoyment of the housing. Most common type of reasonable accommodation that we see, again, is seeking the allowance of an assistance animal where otherwise rules would not allow it, and that would allow the person with a disability full and equal enjoyment of the housing in question. A person could also claim discrimination if they're being discriminated against based on their record of a disability, or if they're not disabled and they're being perceived as disabled. The definitions of disability and substantial limitations are to be construed broadly. Takeaway from this slide is that a person is probably more likely to fall into that definition of disability than be excluded from it, and therefore be entitled to a reasonable accommodation. There are certainly exemptions or exclusions to disability. So if somebody's disability constitutes, or and I'll get to this, their assistance animal constitutes a direct threat, there's no duty to provide that accommodation. That person can be excluded because they constitute a direct threat. So again, a reasonable accommodation is an exception to a housing provider's rules, policies, practices that is necessary to allow a person with a disability the opportunity for full use and enjoyment of the premises. Whether something's necessary is whether there is some sort of relationship between the disability and the accommodation the person is seeking. Again, a person with some sort of mental impairment who benefits from the presence of their emotional support animal is going to seek an exception to a rule that wouldn't allow them to have their emotional support animal in that community. It's necessary because the mental impairment, the nexus between the mental impairment and the animal is that the animal provides that therapeutic effect for that individual. So some examples of HOA cases related to reasonable accommodations. An HOA in Las Vegas in their management company had to pay $65,000 following a conciliation agreement where they refused to grant a family's reasonable accommodation request to be allowed to park an ambulance in their driveway. Now, I understand there's HOAs that have very strict rules. We see a number of these cases related to parking. You know, you can't park on the street, or you can only have one car in the driveway, or you can't have an RV parked in your lot or something like this. I imagine in this situation, this HOA, the rules did not allow for an ambulance to be parked in this driveway. Well, it just so happened this family had a minor child who was disabled, and it was necessary to have this ambulance to transport him. And so they sought an exception to this rule that said you can't have an ambulance in the driveway because this person was disabled and they needed access to that. The HOA denied it. They got hit with a fair housing complaint and ended up having to pay out $65,000. Another example, this one also in a condo where a person who had a service dog was required to use the service door when she was accompanied with her assistance animal instead of being able to use the primary condo entry. Unequal term and condition based on that person's disability, based on the fact that she needs an assistance animal. Assistance animals, service animals need to be allowed anywhere the general public is allowed, including a service animal is going to be allowed on the pool deck. They're not going to be allowed in the pool though. So there are certain limitations, but they're very narrow, very narrow. One of the handouts that's attached here is, as Jeff mentioned, something from HUD. It's called Assessing a Person's Request to Have an Animal as a Reasonable Accommodation under the Fair Housing Act, specifically titled FHEO Notice 2020-01, and it was issued just in January of this year. This is the most up-to-date guidance from HUD on the allowance of assistance animals in housing. Another example of an HOA violating fair housing law by not adhering to it when considering a request for an emotional support dog resulted in a $50,000 settlement. And this Snowmass HOA had to attend training related to fair housing and change their policies in order to be in compliance with this settlement. So it's a big deal. Now, unfortunately, I've gone a little bit longer than I hoped, so I'm going to refer you back to what I just discussed, the FHEO Notice 2020-01, which gives the detailed analysis that is on your screen now. Basically, the important thing to keep in mind is when it comes to assistance animals, they're going to be a form of a reasonable accommodation. If your HOA doesn't have rules related to pets or generally otherwise allows cats and dogs, you're not going to have a problem. It's only really going to be an issue if you exclude cats or dogs or limit their size or something like that. Then it might become an issue. Now, importantly, service animals are always need to be allowed anywhere the public's allowed. Emotional support animals, it's uniquely a housing situation. Assistance animals are not pets, cannot be treated as such. Again, most fair housing complaints, both nationally and in the state of Colorado, involve allegations of a failure to provide a reasonable accommodation. and specifically relate to assistance animals. Again, this full analysis is in that handout. I would strongly recommend that you review that whenever considering any assistance animal complaint or issue. Now, there are circumstances where a person may be disabled and they may be able to show that they have a need, that the presence of an assistance animal is necessary. The animal still may be denied if, again, it poses a direct threat to health and safety of others, and or there's a risk of substantial damage to property of others that cannot be otherwise limited or controlled. If though if an animal is going to be denied in the first place, or if the HOA is going to seek to have it removed, that assessment that it's a specific threat to health and safety or a threat of physical property damage needs to be based on an individual assessment of that animal. And it can't just be based on conjecture. So it can't be something like, we don't allow pit bulls full stop because they're dangerous. That's not an individualized assessment. And also, just as an aside, saying that there's a locality that has a breed ban is not going to be a defense to the denial of an emotional support animal. There's no state or federal agency that licenses, registers, or designates assistance animals, so don't be asking for any license, registration, or certificate. A person might provide you one that might be related to a company that is just trying to further education, but it might be, more often than not, it's a license certificate that is sold by a company that is simply selling individuals a false sense of security, because there's no governmental agency that licenses, registers, or designates these animals. Service animals are defined by the law, not by whether or not they have a certificate, as are emotional support animals. Now, importantly, assistance animals are not exempt from local licensing and vaccination requirements. However, HOAs don't enforce local licensing and vaccination requirements. Usually that's animal enforcement. So don't try and enforce rules and regulations that you do not have the authority to do so. Otherwise, you could be interfering with a person's right to their service or emotional support animal. If you believe there's an issue, bring it up with the proper authorities. What I'm going to wrap up with real quick, because it's simple and also because it is something that you have a handout about, related to reasonable modifications. Now, a lot of people, a reasonable modification is a lot like an accommodation, where there's a request for a change to a rule, policy, or procedure because of a disability. A modification, the request isn't for a change to a policy, but instead to the actual physical property. Now, this physical alteration might be in a common area of the HOA. So maybe there's a pool where the person is seeking the installation of a chairlift to allow a person with a mobility impairment entry and exit of a pool. Reasonable modifications could also be, let's say a homeowner purchases a house and they need to build a ramp at the front door steps. That would be a modification. And an HOA can't deny that to say, oh, well, no ramps are allowed pursuant to our covenant. Accommodations need to be made and including physical alteration of the property. Now, it comes to the payment for this physical alteration of the property, generally speaking, that is going to be on the individual themselves to have to pay for. Really, I can't think of an HOA situation where it would not be the individual themselves, with one exception. Sometimes a person, for instance, might seek to build a fence as a reasonable modification necessary because of their disability, but they live in an HOA that doesn't allow fences. So the HOA says, okay, fine, you can do this modification, you can build this fence, but we want you to use this really premium, expensive fencing material. If the HOA wants this really expensive, nice, fancy, premium fencing material, they need to pay for the extra cost above whatever it would be for just standard baseline material. So if the housing provider wants the modification to be done top of the line finishes, they have to pay that extra cost. Real quickly, I just want to point out that when it comes to housing and COVID-19, covid19.colorado.gov for most up-to-date information related to executive orders and other public health orders. When it comes to housing, DOLA, the Department of Local Affairs, so see dola.colorado.gov/housing-COVID-19. You have the Division of Housing with all sorts of very specific information related to COVID-19 orders and housing.